Court finds Home Office's delay in determining applications to lift NRPF conditions breaches Article 3 ECHR, Systems, Duty. Published by Doughty Street Chambers. The High Court has found that the Home Secretary's system for determining applications to lift conditions of no recourse to public funds, NRPF, for those with limited leave to remain in the UK was in breach of Article 3 of the European Convention on Human Rights, ECHR. Background. When granting an individual limited leave to remain in the UK, the Home Secretary imposes a condition that the individual is excluded from mainstream welfare benefits unless I. They are destitute or at imminent risk of destitution. E. The welfare of the individual's child outweighs the considerations for the NRPF condition. And E. There are exceptional circumstances affecting their income or expenditure. The Home Secretary imposed an NRPF condition in each of the claimants' cases. The claimants are 3 families with children, including 2 single-parent families, who were impacted by the NRPF condition and experiencing homelessness and hardship. The claimants made change of conditions applications, supported by the Unity Project, asking the defendant to lift the NRPF conditions in their case on the basis that they faced imminent destitution and that the welfare of the children required it. The Home Secretary refused their request to lift the NRPF condition. The claimants challenged these refusals and the delays in the operation of the system for determining applications to lift NRPF conditions. By the date of the hearing, the Home Secretary had withdrawn all the decisions on the basis that they were unlawful. In 2 claims, the Home Secretary remade the decision and maintained the imposition of the NRPF condition, some months after they had made their initial change of conditions application. The defendant also provided evidence that the average time taken to determine a request to lift a NRPF condition is 10 weeks. Judgment. On 21 November 2024, Mr. Justice Johnson found that the Home Secretary did not have an adequate system in place to reduce, to a reasonable and proportionate minimum, the risk of inhuman and degrading treatment and held that the Home Secretary was in breach of the low-level systems duty, under Article 3 ECHR, Section 103, Section 118. He held that the Home Secretary's evidence was too vague to show that her system was reduced to a reasonable minimum, Section 99, and that having a case-by-case review, which allowed for expedition where thought necessary, was insufficient to meet this duty, Section 102. The bare minimum required was that the system ensured that applications are considered, on a triage basis, sufficiently swiftly to enable case-by-case review and expedition, Section 102. Mr. Justice Johnson also allowed one of the claimant's claims on the basis that the refusal to lift the NRPF condition was unlawful and irrational, Section 86, and in breach of her statutory duty to have regard to the children's best interests, Section 94. The claimants are represented by Donchad Green, led by Ben Amunwa of 3 petabytes and instructed by Adam Hunt, Brian E. Goodsmith, and Nikita Hedges of Dayton Pierce Glynn. The claimants were supported by the Unity Project.